Yeah, it is afternoon, isn't it? Good afternoon.
Good afternoon. Patrick Dervishi. I'm counsel for the appellant, Riverwalk at Sunrise Homeowners Association. I would like to receive 3 minutes for rebuttal, please. The trial court below deprived the Homeowners Association of the opportunity to present its case at trial. In dismissing the third amended complaint with prejudice against Sherwin-Williams, the trial court basically found two things. One, that the cause of action for negligence against Sherwin-Williams had accrued on or about 2005. Second finding that the trial court made in its order dismissing the cause of action for negligence was that, as alleged in the third amended complaint, the cause of action for negligence against Sherwin-Williams did not constitute a construction defect case. If you look at the order, there is no reasoning provided for the two legal conclusions. We are left here to wonder, what did the trial court find insufficient with the allegations of the third amended complaint? One party below, the Biscayne Painting Corporation, the painting contractor, is not a party to the complaint. Is not a party to these appellate proceedings. That action is still continuing down below. There's 3 causes of action pending against Biscayne Painting, and as you see from the record before you, we went through 3 different amendments. Once we found that Sherwin-Williams had breached its duty to the association. One of the things that we made the case for the claim for negligence was that Sherwin-Williams somehow entered into this symbiotic, if I may call it that way, with the painting contractor. Biscayne Painting is a local painting contractor. It is a major client of Sherwin-Williams. Basically, how the relationship works is the Homeowners Association is in need of painting numerous townhome buildings at the community. We don't know, because the facts were not fully developed in the case below, as to what actually occurred in regards to Sherwin-Williams' involvement in this case. Who found who? Did the association reach to the painting contractor? Did the association get the bid from the local painter from Biscayne Painting from Sherwin-Williams? And that is because we have taken 2 depositions, and again, because of the procedural posture of this case, we never had a chance to fully develop the record, but we were able to take 2 depositions of the Sherwin-Williams quote-unquote professional coating representative. Basically, they are sales representatives that go around, they take jobs, they recommend a painting contractor, they go to the association. Now, what they do is specific, which is something that is very important for the court to make a determination, A, when did the cause of action accrue, and 2, whether this relationship between the parties here on this appeal makes the transaction a construction defect case or something that it is not a construction defect case and it's just a common law negligence.
But let me ask you that. I mean, don't you answer that in your third amended complaint, where you actually allege that Sherwin-Williams was negligent because they failed to inspect, test, and warn. And that occurred, I think everybody agreed, those terms, maybe not warn, but inspect and test, occurred before 2005. So isn't that the answer to your question of when the suggestion is that negligence occurred, or what the duties were of Sherwin-Williams?
Your Honor, we have no dispute as far as the allegations in the third amended complaint that, as pled, those actions complained of occurred on or before the transaction or the agreement that the association ultimately entered with Biscayne Painting. We have no dispute. We acknowledge that, we concede to that. However, this is the first point that we raised down below. The cases that we have cited in the initial brief talk about negligence. But negligence, and I don't want to bore the court with the elements of it, one of them is damages, something that is missing entirely from the order dismissing the negligence case. The court said summarily, I find, which is directly in response to your question, that conduct occurred in 2005. And we don't have a dispute because the amended complaint that Eddie Sherwin-Williams was filed on January 23rd, 2013. So we don't have one of those situations where it's a month before, a month after. The issue is the Homeowners Association. And again, we are talking about a working class community in Sunrise. This is not one of those high-end condominiums on the beach where we know how boards and volunteers and the members deal with issues relating to the community. They discovered the issue with the construction defect, with the painting defects, on or about 2009. So technically, if I have the elements of the cause of action, I have that claim against Sherwin-Williams on or after 2009. That is something that the trial court did not pay attention to, did not give any consideration to. It said specifically, you are alleging under the complaint that this conduct occurred in 2005, you're out. And we said, wait a minute, in 2005, we agreed that the conduct occurred in 2005, but we have damages in 2009.
Did you argue delayed discovery, or did you argue what you just said, which is that the last element giving rise to the negligence claim, which is damages, didn't occur until later?
Your Honor, we argued the first point more than we argued the delay doctrine. Again, we are coming under an extraordinary circumstance, which is dismissing the claim with prejudice based on an affirmative defense. So they have to raise it, and then we have to respond. Very briefly, Your Honor, we went through 3 amendments. We understand the discretion starts to become a little bit higher on the 3rd amendment. You gotta have to get it right. But throughout the briefs, you may have found this scope of work term. We just throw it out there because we don't know. Sherwin-Williams comes in and they prepare specifications. They talk to Biscayne Painting. They have to do what they have to do. It is incorporated under the contract. There is a legal duty. In direct response to your question, they come in a motion to dismiss to the 2nd amended complaint and say, negligence, you're out. Cause of action accrues in 2005, which is what Judge Sicklin mentioned. They don't raise the issue of delay doctrine. We don't raise it because we were going on the opposition to the 2nd amendment complaint. We were arguing this point. However, once we change the allegations and says, wait a minute, we getting a little bit confused about the scope of work. So we try to make it clear that this is Sherwin-Williams, because of this relationship, they have to come in, test, inspect, and warn the association. So we say, this is what we have. And in that way, we address the concerns of the trial court when they say, well, as pled, you were out on a negligence because you're saying they breached the scope of work. There is no privity, as a matter of fact, between the association and Sherwin-Williams. The legal duty is because of the relationship that Sherwin-Williams assumed by its involvement in this transaction, as well as because the contract that we entered into with Biscayne incorporated those specifications, incorporated also a 7-year warranty from Sherwin-Williams. It also said in the contract that a supervisor from Sherwin-Williams will be present in this transaction. Now, going back to the delay doctrine, once they raised it, once they raised the statute of limitations again to the 3rd amendment complaint, we cited to Herndon and we said, in addition to the cause of action and the accrual in 2009, we also have this case about a construction defect. And again, we are here on a motion, on a procedural posture where we have to take the allegations as true. So the legal determination from the trial court should be, well, let's assume that we agree on first point that for the sake of the argument, that this case is outside of the 4-year statute of limitations. Now we go back to the delay doctrine and we say, well, based on the allegations that you have in the Third Amendment complaint, can this be a construction defect? And we rest on our briefs where we identify construction defects, chapters 558. You have to give credence to a specific chapter where it says the painting contract, which is something that they have raised. Oh, this is just a painting supplier. This is just a painting job. Well, it's not that. It is $75,000 a contract, and it is not just a painting supplier. It is also Sherwin-Williams, who has substantial involvement in the case. So we're not talking about. There should not be a dispute about the reading of the statute. I think the reading that they have in the answer brief, they keep it very truncated, and they say, well, the painting supplier does not come within the statute. It is improper to say that because when they raised this argument, the very first time that they filed a motion to dismiss, guess what they asked the trial court? Stay the proceedings or abate the proceedings because the association has failed to provide the 558 notice, construction notice, to Sherwin-Williams. And now they have gone 360 degrees and say, well, this is not a construction defect case, and we have to deprive the association of their opportunity to present the case. Again, to legal determination. Again, you should find the damages, and we have cited the cases where they specifically say the Ishii case, which is a case that says you have a negligence against Barnett Bank because of transfers of money. The cause of action accrued when she got notice and the damages were suffered. The same way on the Sussman case that we have addressed in the initial brief, there was negligence by the title agent, and the court said the title agent had messed up the loan documents. The negligence did not occur when the title agent prepared the documents which constituted the negligence. The negligence occurred, the cause of action accrued when the mortgage went in default. And I have all those cases in the initial brief, and I'll address any other concerns that you have. I know I'm rushing a little bit.
Yeah, well, you're over your time, but I'll give you a minute to rebut, okay?
Thank you very much, Your Honor.
Thank you.
May it please the court, Cindy Mishkon from the law firm of Lewis, Brisbois, Biscard, and Smith on behalf of the defendant below, who's the appellee on appeal, the Sherwin-Williams Company. The basis of the motion to dismiss the Third Amendment complaint was that the allegations as pled did not establish that the negligent acts occurred within 4 years of the filing of the original complaint against Sherwin-Williams. I think by admission, all acts alleged in the Third Amendment complaint occurred prior to May 2005, which is when Biscayne Painting entered into the contract to paint the exterior of the association's buildings.
Well, let me ask you this, though, because in the Third Amendment complaint, the association does allege in paragraph 55 that sometime in 2009 the paint began to crack, chip, flake, and otherwise fall off the exterior of the building. So isn't that arguably then that notice to the injured party that triggers the running of the statute?
Your Honor, I don't know of any case, I don't know the mortgage cases that he's talking about, but I don't know of any case that refers to negligence cases outside of a delayed discovery. The damages occurs when the negligence occurs. Like in this case, if the wrong paint was used, the damages occurs when the paint is applied. For example, you won't have to wait till 2009. Let's say you knew the wrong paint was applied. You won't have to wait till 2009 to seek relief. If the wrong paint is used, that's when the negligence occurs, and that's when the damages occurred.
But that's only if you know the wrong paint was used. If you don't know the wrong paint was used until it starts to fall off the building, why doesn't that equate to the last element of negligence, that being damages, and therefore the statute runs then?
Well, I have two responses. The first is because the Florida Supreme Court has said that we don't recognize a delayed discovery rule unless there's a statutory exception to it. The statutory exception that they're traveling under doesn't even apply because it requires the construction, and we don't dispute the word construction. What we dispute is that it was a construction to an improvement. Painting a building is not, by definition, an improvement. And in order to come under 95.11 subsection C, I guess, or subsection 3, it requires there to be an improvement. And the case that we rely upon is Pinnacle Port Community Association, which involved restoring stucco walls to a non-leaking condition. And in that case, this was the 11th Circuit Court of Appeals, but it was decided under Florida law, under the exact statute that they are traveling under. And in that case, the court held that restoring stucco to its non-leaking condition is a repair. It's not an improvement, and therefore it doesn't come under 95.113C. So that's the exact argument that we're making. And in the face of the complaint, all it alleges is that they were hired to paint the exteriors of the building. That's a repair. That's not an improvement to real property under 95.113C. And the definition that the court was reading in that case, it was based on Black's Law Dictionary. The word repair contemplates an existing structure or thing which has become imperfect and means to supply in the original structure that which is lost or destroyed, and thereby restore it to the condition it was to which it originally existed as near as may be. That's what this was. This was a contract to paint the exterior of the existing buildings that had been constructed long ago. It was just a painting contract to bring it to its original condition. That's a repair. That's not an improvement.
But I mean, but that's like saying though, and Sherwin-Williams is only one of the largest paint manufacturers in the world. I mean, yes, it was only a painting job, but for that they relied on Sherwin-Williams, is their argument. Let me ask you though along those lines, because what your opponent's suggesting, we don't even need to get to the delayed discovery notion here, because all we have to do is just look at the statute and look at when they first started suffering damages, which was in 2009. Why don't you think that holds water, that argument? Because Sherwin-Williams' work was done in 2005?
Sherwin-Williams' work was done in 2005. The allegations of negligence against them are testing, inspecting, and warning. That occurred in 2005. And again, it's my position that the damages actually occurred in 2005. They may not have known of it, but Florida doesn't recognize a delayed discovery rule unless there's an exception. And that's the only argument that I'm making. They may not have known of the damages, but the damages occurred in 2005. It just took them several years, according to the complaint. They didn't learn of it until 2009. But again, I think the Florida Supreme Court is very clear that unless there is a delayed discovery exception, the 4-year statute of limitations applies. And it's
Which case do you cite to for that? When you say
oh God, it's the one dealing with the child sexual molestation.
Oh, okay.
But they're very clear in that case. Unless there is a statutory exception, there is no delayed discovery. That case was a child molestation, and at the time there wasn't the statute. There now is. So for that particular circumstance, they created it. That's not even necessary anymore because the statute does exist for that. And again, if you want to rely on the 95.113C, you still have to have an improvement versus a repair.
Why wouldn't you rely on 95.113A, which is an action founded on negligence?
That's what I am relying on.
Well,
That's
you're
that's
saying
my
no, you're-
argument. They're relying on 3C. Our argument was under 95.113A, that's the 4-year statute of limitations
Correct.
for negligence. They came in and then said, well, no, this is a delayed discovery, and we're relying on this to get around the 95.113A.
I'm just so confused because, I mean, when I just go back to law school, general tort principles, I just always, thought that an action for negligence doesn't accrue until a plaintiff actually suffers a loss or some damages. Not necessarily when the negligent act occurs, but when the plaintiff actually suffers some damage, when the negligent act actually causes damages. That's when I always thought that an action for negligence would accrue.
Well, again, the negligent act results in damages when the negligence occurs. That's the reason that they created these exceptions, because in certain situations, you don't learn of it until long after the fact. So for certain types of things like a latent construction defect, they've created a delayed discovery exception to the general rule. They're traveling under one of those exceptions, but in order for that exception to apply, it needs to be an improvement, not a repair, and painting existing buildings is a repair. Have I explained?
Well, I mean, I had the same problem as I was in the dissent in the medical jet case, because the majority said it was delayed discovery, which didn't apply, and I said, no, it's just an element of the cause of action that occurred later. But I lost
But
that
if that was
battle
the,
too.
if that was the case, then there would never even be a need for this latent construction defect case. You know what I'm saying? Because
I do know what you're saying, but I
Right.
think there are some instances that the last element to the cause of action being damages doesn't happen until after 4 years from whatever was done. And that I don't think is delayed discovery. I think that's accrual of the cause of action. So,
yeah, but I think in the construction cases, there would never, if that was the interpretation, there would never be a need for this exception under 95.113C, because that would be the situation in all cases. We didn't know about it, you can't see it, we don't know about it.
yeah,
So,
yep, I agree.
so we would ask that the dismissal please be affirmed. Thank you.
You want to take a minute and,
I will try to do my best, Your Honor,
Okay.
and I think I'm going to try to explain. I think this discussion with opposing counsel explains why it is so difficult to engage in these legal arguments when you have a special set 30 minutes and then you have two motions to dismiss and you're trying to rush all the legal theories before the trial court, because then your case is dismissed. In direct response to the two questions. Two separate arguments. The cause of actions for negligence, 4 elements. Law School 101, you need to have damages. If you look at the cases that we have cited in our brief, and one of them, all of them relate to this issue, but I'm going to cite to Schoenberg versus Panorama Custom Home Builders, 2nd District Court of Appeal, 2007. I am just going to say one word or quote one sentence from that opinion. Damages are an element of a cause of action for negligence. In that case, there was a construction negligence case, where the homeowner sued the builder, and then there was an issue with mold and mildew outside of the statute of limitations. And in that case, it was reversed because the cause of action for negligence required damages. In this case, we don't have, or at least at this point in the proceeding, we don't have damages because the wrong paint was supplied. We don't claim that. We don't know that yet, because Sherwin-Williams, when they came back in 2009, they ran the test, and guess where they point the finger? Biscayne painting, because they didn't properly cure the exterior walls, and they probably didn't put the primer. And there is factual issues about what kind of primer, what kind of seal. One issue. Can this case be not a construction defect case? Yes, and in that case, you go to 95.11.
A, right?
Yes, A.
But she's
separate.
saying you argued C.
But Judge, no. Respectfully, I think that is the confusion that they have presented below and in the answer brief. They say that we are going through the exceptions, and the exception is, going back to your question before, we have a negligence cause of actions. You don't have to go to the exceptions, because even if this case is determined to be not a construction defect case, then in that case you have a negligence, straight negligence cause of action, 95.11a, when the question becomes, when did the damages occur? In 2009. So at this point, we may have to dispute that fact. They may have to dispute that fact, but until the record has been developed, we need to go to a summary judgment at the very least. Now, what our position in the alternative is, and maybe not as clearly shown from the record, is if you want to find without any regard and adopt, which is the case below, the court did not mention anything about the damages in 2009. They said exactly that. Actions complained of occurred in 2005, you're out. So now we take the position that when that case happens, alternatively, this case is also a construction defect case, which by statutes, just reading the statutes, it makes the accrual of the cause of actions when you got notice of the defect. And for that, now going back to an interpretation which requires a full record below, because we have presented in the initial brief and also in the reply brief, the statutes where we say you have to look at Chapter 558 construction defects, where it specifically says construction defect means a deficiency in or a deficiency arising out of the design, specification, surveying, planning, supervision, observation of a construction or construction, repair, alteration, or remodeling of real property resulting from, and it lists four, one of them being failure to construct or remodel real property. They conclusory, they follow on the same track that the trial court fell by summarily rejecting the argument and saying this is not a construction defect. For that reason, we are asking the court to reverse the order of dismissal. We need to go and deal with more facts so that the court can have a full record, and maybe the trial court can come into the decision that this is not a construction defect. And I appreciate the fact that you have given me more time than allowed. Thank you very much.
Thank you, folks. All right, we'll be in recess.